Alyssa might appreciate a chance to answer some of the questions.
And I did send her additional ones as well.
Good.
Mm-hmm.
So,
hey, everyone joining us on the attendee side, thank you so much for being here. It's going to be a couple more seconds before we get started. We're waiting for everyone to come in from the waiting room, so just give us a couple more seconds, okay? Okay, it looks like we've kind of leveled out a little bit. We have more than 100 of you on the webinar, so I really appreciate you being with us today. My name is Anna Tazan. I'm the Chief Revenue and Innovation Officer with the Texas Restaurant Association. We're really, really happy to be doing this webinar today. I do need to remind you all, though, that this webinar is specifically for restaurant owners and managers. So if you are an employee of a restaurant, we will answer your questions as best we can, but it's best if you just email us, or we can give you a phone number to call maybe at the beginning. But most of this conversation is really going to be geared around owners and employers. So if you're an employee, I would recommend calling TWC directly to get your question answered. Okay, that said, we already have like a long list of questions, and Commissioner Aaron Demerson has been gracious enough to give us an hour of his time along with his staff. We've got Brian and Tommy and Melissa with us too, who will do their best to answer all your questions. So use the Q&A window if you have questions to ask. And in the meantime, Commissioner, I'm going to turn it over to you.
All right, thank you so much, Anna. Thank you for the opportunity, and make sure you let Emily know that we appreciate us working with us so fast in that regard. We really want to just say thank you on behalf of Governor Abbott, who appointed me to this position in August 2019, just to say thank you for what you guys are doing. You're members of the organization. We know these are really tough times, unprecedented, uncharted, the like, but we're Texans and we're very resilient, and so we're looking forward to the what's next. And so, but thank you for what you're doing, not only today, but the investment that's been made in our state by so many of you over the years. And so tough times, we're going to get through it. And thank you for just taking care of business in a big way. I have the privilege of serving as the commissioner that represents the employers for the state of Texas. I have a dynamic team here. We have 4 employment attorneys on board. Tommy Simmons, who's joined me, Melissa, who's on the phone, Melissa Chapa, Mario Hernandez, and then Elsa Ramos as well. You can only imagine the calls that they've been receiving this past 2 weeks, and it's been they've been just tremendously answering questions, taking care of business. We've been on 2 similar conference calls already today with a number of different employers out there, but we're excited about what we have to offer in our job here, and we care about our employers in Texas. That's where the rubber meets the road. You guys are employing our Texans, and we don't take that for granted, and anything that we can do to help, we're going to do exactly that. There's a frequently asked question document that's we've shared with the Texas Restaurant Association, and they probably have shared it with their members, and we're going to continue to update that to get that information to you guys as well. I also want you to know that at the local level, we have a Workforce Solutions office, and that's statewide. And so there are Workforce Solutions offices statewide that I encourage you guys to touch base with, to get to know even now and in the future. Those are going to be excellent resources for you as we go forward, and we'll continue to make sure that those are available for you as well. Before we get to Q&A, and that's what we really want to get to, a couple of things. Governor Abbott, a couple of weeks ago, we were actually able to take away the waiting period. You know, there was a 1-week waiting period, and we were able to kind of move that out of the way through the unemployment benefits, the claims in that area. In addition, our agency waived the work search requirements as well. Our executive director, under the authority that was dedicated there, was able to waive the work search requirements. And then another area, the SBA, there was a disaster. Governor had requested a designation, and we received that designation from the SBA. And there's an economic injury disaster loan program that's available right now. And we were on a call yesterday with the SBA, and they're really working hard to make sure that applications come in and that we're taking care of our businesses, operating capital type initiatives and the like. We're really interested in hearing from you guys, any innovative approaches, things that we may not have considered. We'll be making sure that we're getting that to the proper sources. And there's a program, the Shared Work Program, that's a creative alternative to the layoffs. That may be something that we want to encourage you guys to look at and look into as well. But the employment law attorneys here, the staff that we have here in the Commissioner's Office that represents employers, we're excited about the opportunity to help, and we want to make sure that we're doing our best to answer your questions and move forward in any way that we can. And so my thanks again to the Texas Restaurant Association and you guys for calling this together. It's not our last time. We have an 800 hotline number. I know the team's been in touch with you guys a number of years. Tommy and the rest of them have worked with you guys a number of ways, and we're looking forward to moving forward. So with that, I will go ahead and start asking some of the questions. We're going to get to the questions, and then I have Tommy over here that'll join me. I'm going to move a little bit because I want you guys to make sure you see Tommy there. We're kind of going to do this in the essence of social distancing as well. And so the first question, it says, for disaster layoffs, and I'm going to move off screen a little bit and I'll read this and you can hear me, and Tommy will answer these questions, and Melissa on the other line or the other attorneys would join in as well. But it says, for disaster layoffs and staff filing for unemployment, which I think they should and need to file, has TWC offered any guidance assuring employers unemployment tax rates are not going to be affected by these filings?
There's good news and bad news on that. The good news is that direct chargebacks of benefits will not go on to employers' tax accounts. Employers will get chargeback protection for any work separation that is the result of COVID-19 or the pandemic or shutdowns or closures or anything like that. The bad news is that the chargebacks that cannot be charged back effectively to a particular employer's tax account must be recovered in some way, because federal and Texas law require stability in the trust fund. You have to have enough money to pay benefits with. The way that money is recovered is through an indirect mechanism, which will not take effect until the following year. That's called the replenishment tax and the replenishment ratio. 50% of the ineffective chargebacks are recovered through the replenishment tax. That's the minimum tax rate that employers with no chargebacks during the past 3 years have. This year it's 0.31%. The replenishment ratio is a modifier to the benefit ratio, which is relevant for employers that have a 3-year chargeback history. And between the two of them, that replenishment tax and replenishment ratio are designed to help the trust fund recover. But sometimes during times of extreme stress, that's not enough to totally do the trick. And from past experience, most recently, the Great Recession that started, big time back in 08, it hit its peak in 09, and it kind of dwindled away after that, all the way through 2012. During that time, there was a deficit tax, and the deficit tax arises if there's not enough money in the trust fund to pay all the benefits, and we have to borrow money temporarily from the federal government, in which case there is a deficit situation, and that's recovered through the deficit tax. And there are other mechanisms as well, but those are the three main ones. So for 2021, it's foreseeable that we will have some amount of deficit tax and some kind of increase in the replenishment tax and the replenishment ratio. We don't know what that's going to be. Time will tell. What happens between now and September 30th will tell the tale, because the time between October 1st and September 30th is the time period used by the tax department to look at the numbers and determine at what level the replenishment tax and the replenishment ratio need to be, also the deficit tax. So there will be some effect, but it'll be spread out or distributed among all employers that pay taxes in Texas. So everybody will help kind of carry the load a little bit on that one.
Okay, good. And so we'll move to the next question. And the screen has Brian Owens. Brian's the chief of staff here. This is Tommy Simmons that's talking, and Aaron Demerson on the other side. And so someone called me with a question regarding letting employees go so they can get unemployment. Does it change the rating?
The answer is that if people are let go because of COVID-19, if it's in any way an unavoidable downsizing or reduction in force or layoff due to COVID-19 closures or shutdowns or anything like that, then there should not be a charge to the employer's account directly. But if a work separation is not caused by COVID-19, then it'll be evaluated on the real reason for the work separation. If it's an ordinary layoff that doesn't have anything to do with COVID, then presumably that would be a chargeable work separation.
All right, and will tipped employees be able to claim unemployment for their tips that are claimed on their taxes?
Yes, tips given to tipped employees are defined in our Texas Unemployment Compensation Act as part of remuneration from employment. That means wages from employment that are reportable on a quarterly basis to the TWC. And the benefit amounts of claimants will be evaluated individually for each separate claimant based on their own individual earnings history during the base period of their claim. Whatever wages have been reported by employers during the base period of their claim will determine their weekly benefit amount and their maximum benefit amount. So if those, assuming the tips have been reported to the TWC as wages, then yes, that will go toward computing their benefits.
All right, so the next question deals with employees that work for multiple businesses of ours have only been able to apply for unemployment benefits for one location. How can they apply for all businesses they work for? And then it goes on to say the TWC website will not allow them to apply for more than one, although all of their jobs are shown, and they cannot reach anyone by phone as the lines are busy. I'll take the last half of that. The lines that are busy right now, we're addressing that situation in a big way. We had originally the bandwidth that was that problem that we were dealing with. Right now, there's a document that I'll share with you, Anna, that talks about what we're doing in terms of the problems for folks that are fixing a claim, filing a claim. Right now, agencies are open from 8 to 5, 8 to 6. We're expanding those hours and working on the weekend as well. We've talked about maybe calling in at times outside of the normal work hours or so, and then maybe that speeds up the process as well. And we're working with AT&T as well to increase that call. And we've had a number of individuals reaching out to us to offer their assistance as well. These numbers that we have coming in are uncharted, unprecedented. We've not seen call volumes at that level, but you can rest assured the agency is working hard to make sure that our Texans are in a position to get answers to the questions that they have. And so I know that that's ongoing work that's been done in a good way. And so hopefully that will limit the amount of folks that are not able to get in. I'll turn to Tommy for the first part of the question.
Yes, sir. All of those employees who work for multiple locations of, perhaps different locations of a franchisor, maybe different franchisee locations if they're separately chartered and they have their own TWC tax accounts, those employees don't need to file an unemployment claim against each one of those employers. They only need to file one initial claim listing their last employee unit, the very last place that paid them wages for work. Because the system will automatically involve all of the base period employers in that unemployment claim. The last employing unit will get a notice of application for unemployment insurance. That's the notice of initial claim. And the other base period employers, the associated businesses perhaps, they will receive a different kind of claim notice called a notice of maximum potential chargeback. And depending upon the reason why the claimant stopped working for each of them before the claim was filed, they may or may not get chargeback protection. But if it had something to do with COVID, then they should be able to ask for chargeback protection just like the last employing unit. So everything depends upon the reason why they stopped working, but above all, file a timely response to each claim notice. So if you have different aspects or portions of your business that are getting different kind of claim notices, it's important to respond in a timely manner to each one.
Can furloughed employees continue to have company health insurance?
The answer to that would be yes, they can. If their health insurance benefits are being continued on their behalf by the company, that's not considered to be, wages from employment that would prevent them from being considered unemployed. They should continue with whatever health insurance benefit they can manage from their company and be glad for it. But that should not prevent them from filing unemployment claims. So they should file the claims and just answer the questions. That circumstance, though, should not prevent them from drawing benefits.
Okay, so that's collecting unemployment and continue to have health insurance.
That is correct.
Okay.
It's not wages from employment. It's a financial benefit, but it's not wages in return for personal services. They're not working to get it because they're obviously not working while they're furloughed.
Okay, and so I asked this question, Melissa, if you have an answer for this perhaps as well, and Tommy, the other of it. It says an employee walks out of work, does not return, and they will not return emails or phone calls. They claim that they are scared to work. Did they quit? Are they still employed? Can we replace them or what?
So for essential businesses or essential workers, the truth is that if they are needed there, the employer needs someone to do the work, then that's the reality that the employer is in. So if someone is walking out, and that's happened from several calls we received where they're just refusing to come in because they're scared, at this moment in time, I am unaware of any job protection that could be extended to those workers on that. Employers may want to communicate with that employee and confirm, what they're planning on doing, if they're planning on just leaving indefinitely, or if they're trying to do a 2-week thing, just to see what the employee's intentions are. But either way, employers, can't force people to come in and work, but they can let the worker know, this is what I'm perceiving. And if we're not back by, this date or this time, I may need to replace you, because that's all that employers can really do at this point. They need to keep the trains running.
Okay, and Melissa, and if this employee, they're not returning emails or phone calls, anything in that regard?
Yes, so if they're non-responsive, that may suggest that they are quitting. Typically, 3 days of no call, no show, consecutive days under our Texas unemployment rules would mean that they've abandoned the job. So if it's 3 consecutive days that they were scheduled to work and they don't respond, under our TWC guidance, that would be looked at as a voluntary quit through job abandonment.
Good. That's Melissa Chopper answering on that side. And so, thank you. Will employees have benefits held from them if they can't go out looking for a job due to stay-at-home orders?
So this is Melissa. Oh, sorry.
Yeah, and basically that's covered by what Commissioner Demerson said earlier about Governor Abbott waiving the waiting week and our executive director waiving the work search requirement. Between those two actions, 2 very important eligibility requirements have been waived to increase flexibility and, kind of speed the economic recovery. So an employee who is, laid off or they quit or somehow they lose their job because of COVID-19, they will not be subject to a work search requirement. And in fact, the work search waiver extends even to non-COVID-19 related work separations. That's because even people who didn't lose their job because of COVID-19 would still have extreme difficulty searching for new work, because a lot of them are in cities where there are shelter-in-place orders, or the businesses where they might otherwise search for work have been ordered to close down. So that's why the work search requirement has been waived for the foreseeable future while this pandemic emergency still exists.
Okay. And this question may have been asked, it looks like it's asked a different way, but it says employees with reduced hours being told it's a furlough can still file for benefits. Is that true?
That is true. A furlough is just a temporary layoff by another name as far as the TWC is concerned. So if they are on unpaid furlough status due to COVID-19, they can file unemployment claims, and they should explain how it's related to the pandemic circumstances. And the employer should also respond that the furlough was based on some kind of circumstance relating to complying with a shutdown order or the economic effects of COVID-19 or something like that. But there should be chargeback protection available to businesses in that circumstance.
All right. Thank you, Tommy. Some employees, when filing, selected COVID-19 as a reason for layoffs, but the form says permanent layoff, and some show disaster as the reason, no longer employed. Does that matter?
It actually does not. TWC staff, are trained to recognize work separations that are ultimately derived from COVID-19 problems. So whether it's described as a permanent layoff or a temporary layoff or a furlough or some other circumstance, if it has to do with COVID-19, it'll go through as a pandemic related claim and be a non-disqualifying work separation and chargeback protection for the employer. The forms that are used by claimants to file claims, there's only limited space for different descriptions of types of work separations, and that's why there's not a very wide selection of possible circumstances. So it's very broad categories, and that's why sometimes something like the COVID-19 layoffs could show up as a permanent layoff, when in reality it's intended to be only temporary. But either way, it should not prevent payment of benefits.
Okay. And what will this do to employers' unemployment tax rate for 2021, considering these claims are due to no employer?
Well, that has to do with the chargeback protection for private sector taxed employers. They will get no direct chargebacks on their tax accounts for any COVID-19 related work separations, but there will be an indirect increase in their tax rates foreseeably for next year due to the way the Texas Unemployment Compensation Act recoups losses in the Unemployment Insurance Trust Fund, out of which benefits are paid to Texas claimants. So that'll be the replenishment tax and the replenishment ratio, and possibly a deficit tax if Texas has to borrow some money from the U.S. Department of Labor. That's how that will be addressed.
Thank you. And what should employees do if they are reinstated once the restaurants open back up?
Basically, they should stop filing for benefits if they return to their regular jobs with regular hours. Mm-hmm. But if their hours are still affected, like previously, let's say they were working full-time or 3/4 time, but now they're only being given quarter-time hours or half-time hours, they may still qualify for some level of partial unemployment benefits. And if they do, then they would be allowed to continue filing for partial unemployment benefits until they return to their regular hours.
Good. And so will employees be paid 100% of their earnings for 4 months?
No. The regular unemployment benefits are about half of the employee's normal earnings. Just mathematically, that's how unemployment benefits are calculated. Now, it is true that under the so-called Phase 3 stimulus legislation that is being finalized in Congress right now, there are supplemental unemployment benefits as high as $600 per week for claimants, and the amount varies according to prior earnings and so on. But there's supplemental unemployment benefits and there's extended benefits, but the benefit amounts do not replace 100% of the lost salary.
Good. And will higher paid salary employees be eligible for 100% of earnings?
The answer is no. The weekly unemployment benefit amount in Texas is capped for the current year, the current fiscal year, at $521 per week. That's the most that anybody with any level of earnings in their base period can draw, regardless of their prior earnings. And a good general rule for figuring out what the weekly benefit amount is, take their annual compensation and divided by 100. And so that means that employees with annual earnings at $52,100 or higher will see only $521 per week in benefits, and the unemployment benefits pay a diminishing percentage of their regular wages. The higher their annual earnings go up. So it's only partial income replacement, and it's only temporary, but there is a limit. There is no program that reimburses 100% of earnings except for private supplemental unemployment insurance that is available through third parties.
All right. And so if employees are forced to work at reduced hours, may they make a claim for the difference in hours that they would normally work?
That's an interesting question, and that raises the issue of shared work plan claims. Under the shared work plan, very, very innovative and highly recommended program, an employer can work out an arrangement with the TWC and with affected employees that for the designated set of employees, their hours will be reduced by a standard amount between 10 and 40%. And if that happens pursuant to the plan, they can receive the same percentage of their weekly unemployment benefit amount that their hours have been reduced. So a 20% reduction in hours would get them 20% of their weekly benefit amount. Mathematically, that would work out to 10% of their normal weekly earnings, leaving them with 90% of their regular weekly earnings, as compared with if they weren't a participant in that claim at all, and they were just getting their reduced wages, that would be 80%. Or if they quit altogether, they would only get about 50% of their regular earnings. So participation in a shared work plan is really the best available method, in my observation, that is available under the law. It's highly recommended for both claimants and employers. It's especially good for employers because with a shared work plan, it's much easier to keep those trained, experienced employees close to your company. It makes it much less likely that they will go elsewhere and you lose that investment in training and experience that you made in them. So talk with the TWC if the facts merit, like multiple employees at one time, and it's only reductions in hours between 10 and 40%, look into the possibility of a shared work plan. And you can find that information on our website, just in the search box on our homepage. Enter the words shared work plan, hit enter, and then click on the first link that appears at the top.
All right. And then how long will a claim take from beginning to time of payment?
All right. Claims are filed 2 weeks at a time. From the effective date of the initial claim, the soonest that could happen would be 14 days after the effective date of the first claim, which would be a Sunday. All claims are backdated to the preceding Sunday, regardless of what day during the week they're filed. So if one is filed today, it would be backdated to Sunday, March 22nd. And then 2 weeks from that day, they could file their first two claims with no waiting week requirement. They can get paid for week 1 and week 2 after that claim is filed and processed. The processing may take a few days, but sometime between 2 weeks and 3 weeks out, they should be able to get their first payment.
Okay, and so those are questions that we've received, and we have about 23 questions that are 23 or 28 questions that are actually have been submitted in, and so I'll go through those, Anna, if that's appropriate as well. And so we'll just keep rolling there. It says, I would like to know the correct way to notify a salaried employee that their salary will be temporarily reduced while these restaurants regulations are in effect. I saw on the DOL website, Department of Labor website, that we can do that. So again, I'd like to know the correct way to notify a salaried employee that their salary will be temporarily reduced while these restaurants regulations are in effect. Saw this on the DOL website that we can do just that.
That is true. And Melissa, feel free to chime in on any of these questions that I'm answering, because we also want to hear your insight on especially like policy issues and stuff like that. But the answer to this is yes, you can do that. That may affect their status as a salaried exempt employee, but of course, that's relevant only for avoiding the obligation to pay overtime pay at time and a half. So if they're not working overtime, in fact, they're working, less than 40 hours a week, that overtime is not going to be an issue. So it doesn't matter if they lose their salaried exempt status for a while. You can always return them to that status following, the conclusion of this pandemic emergency.
Yeah. Melissa, anything on that?
Just to add to that a little bit, I would say that if you're going to be reducing their pay, you need to put it in writing. That would be recommended with an effective date so that they know when that is to begin. And Tommy, correct me if I'm off on this, but since salaried employees are paid week by week and each employer selects what their work week is, some have Saturday to Sunday, some have Friday to Saturday, that employers may do well to follow that. And beginning the next effective work week, their reduction would be at X amount of pay, just to put it in writing so that everyone is fully aware of when that reduction is supposed to begin.
Yeah, perfect. Advance written notice of changes in pay. And if the employee stays with the company after learning of the change, then under Texas law, employment at will, they're considered to have accepted that change. And it's always best from a payroll accounting standpoint. It's much, much easier if you make any pay changes effective with the start date of a new pay period. So always try to announce any changes like that at least one full pay period in advance.
Okay, thank you. It says if we cut manager salaries by half, can they apply for unemployment, health benefits, and unemployment?
Cut managers' salaries by half. That might qualify them for partial unemployment benefits if they also have a reduction in hours associated with that. If it's just a pay cut, then partial unemployment benefits would not apply because they'd be working their usual customary full-time hours. But it may give them good cause connected with the word to quit. If they've got a 50% pay cut, that would fit within the 20% rule guidelines used by this agency to decide whether somebody has good cause connected with the word to quit. So just be attuned to that issue.
Yeah. Melissa, anything there?
I would just add that if there is going to be a pay cut between 10 and 40%, as Tommy said earlier, the shared work program might be a good idea there. If there is a way to prevent or to avoid a pay cut beyond the 40%, then that might help employers so that if they quit and file for unemployment, the employer would not be charged.
Okay, and thank you. And so this kind of, I'll read through this, but it I don't know if it means what is your workload or what is your workload like and how fast can you pay benefits for mass filing? Why slow down the process under disasters to get employees to again ask for benefits? And so we'll try to read through that question to see if we can decipher it a little bit. Workload like and how fast can you pay benefits for mass filing? Why slow down the process under disasters to get employees to again ask for benefits?
I think if you want a little clarification on this, I think what he's asking is like what's your backlog like how long is it taking to process, and then is it faster for employees to receive benefits if you go through mass filing or for them to do it individually?
Okay, thank you.
Yes, it's definitely faster to handle it through the mass claim process if you can do that, and that requires a mass layoff involving 10 or more employees, and that needs to be worked out ahead of the actual layoff. So definitely get on the TWC web page at twc.texas.gov and in the search box put mass claims, hit enter, and then the very first search hit will be the link to the mass claims page. All the steps are outlined there, and basically it's got to involve 10 or more affected employees, and it's pursuant to an actual plan that you work out with the agency. That's the fastest way for unemployment claims to be processed if you can do it that way. And I'm not sure about the thing about slowing down. I know that our agency is doing its best to try to keep up with the incredible upswing in claim filing activity. It's unprecedented, literally unprecedented. It's never happened before in the history since 1936. The system was created back in 1936. We've never had, drastic changes like this, but we are dealing with it. Our executive director and the unemployment insurance director, in fact, have done things such as reassign 200 tax department employees to work on unemployment claims and to handle the increase in claim load. And things like that will help our agency, get to these claims a lot faster. But yeah, the agency is definitely doing everything that it can.
Tell me, give that email address again for that mass claims.
Mass claims is, it's linked on the mass claims page. And so go to twc.texas.gov. In the search box, click on, enter mass claims, those two words, and hit enter. The very first search hit will be the mass claims page. In the middle of that page is the email address, and I think it's ui.massclaims@twc.state.tx.us, but don't take my word for it. Look on the page and there's a direct link, and when you click that link, you can send an email that way.
All right. So we'll get to this next question. It says, which quarters are in the employee's base period for determining eligibility?
Valissa?
Yes. So the 4 quarters, so the calendar quarter that they filed for unemployment and the quarter before that don't count. It's the 4 quarters behind that that would make up the base period. So if someone files before April 1 right now, they'd be filing in first quarter. So the base period would not be first quarter or fourth quarter of last year. It would be third, second, and first of 2019 and fourth of 2018. Similarly, if they file between April and July 1st, or the end of June rather, then the base period year would be all of 2019.
Good. Thank you. So if our employees have filed for unemployment, let me make sure I have this right. Questions are continuing to come in. If our employees have filed for unemployment already, how are we supposed to answer those claims once we receive the forms from TWC? If our employees have filed for unemployment already, how are we supposed to answer those claims once we receive the forms from TWC?
Yes, the best way to handle that is just state the facts as you know them. And I think most of these are going to be dealing with the effects of shutdown orders in various cities for restaurants and pubs and other facilities like that. And they're all going to be closely related to the COVID-19 pandemic disaster. So just state it that way. If your business was shut down by the city, then state that fact and include a copy of the shutdown order that you received from the city or whatever the notice was that you acted on, and that'll show that you should be qualified for chargeback protection. That's definitely the best way to handle it.
Okay. And Lisa?
Yes, and to add a little bit to that, sorry, just a quick note. As Tommy stated earlier, employers' accounts should not be charged for this, for reductions or layoffs due to COVID-19, should not be charged is the key language. So when employers are getting notices of these claims, what they may want to do is respond before the deadline passes to preserve their right to appeal. That way, if the employer's account does get charged, they can appeal it and argue that it shouldn't be charged because the reduction or the layoff or the closure was directly related to COVID-19. Hopefully, the chargeback protection will be automatic, but just in case, I think it might be wise for employers to stay on top of the claims, and typically each one would need to be responded to individually.
Thank you, Alyssa. So all employees eligible regardless of hours worked per week, all hours are part-time. So cutting hours but keeping employed would be better for them to get unemployed. So I think that's going to deal with shared work in some cases. And so again, all employees eligible regardless of hours worked per week, all of hours are part-time. So cutting hours but keeping employed would be better than them to get unemployed, become unemployed.
That's correct. Whether the reduction in hours is a standard one across the board, 10 to 40%, and thus eligible for a shared work plan, or it's individual under partial unemployment benefits. Either way, it's going to be much better for those employees who remain employed and work as many hours as the company makes available to them and report their work and earnings. Those individuals will always end up with more money from a combination of benefits and wages than employees who are just totally unemployed and they're not even trying to work the hours.
So there was a question on how would I reset my password? I've gone through the appropriate steps. I know we've had some work in regards to passwords. I think they were sending out new and additional information on the reset of those passwords. And so if you get that to us, whoever asked this question is anonymous right now, but if you can get that to us directly, we'll walk that through in the sense of getting you information on how to get that password reset and taken care of. We'll do that fairly quickly.
Yeah, ombudsman at
Yeah,
TWC.
the ombudsman office at TWC. Ombudsman.
You can send it directly to the office that will handle it. If you send it to ombudsman, ombudsman at twc.state.tx.us, and it'd be just like, hi, my name is John Smith. I'm a claimant. I'm trying to file a claim, but I'm having a problem with my user ID or PIN. Can y'all help me or reset my whatever? They will get it to the proper people in the unemployment insurance division and get direct help that way.
Okay, so let me make sure that we're not losing any of the questions here. It says, what is the max amount when combined with the stimulus bill amount that a person can receive? I've seen that employees making up to $75K a year will receive full pay while on unemployment. So what is the maximum amount when combined with the stimulus bill amount that a person can receive? I've seen that employees making up to $75,000 a year will receive full pay while on unemployment.
Okay, that sounds like it is connected with the supplemental insurance benefits that are part of the phase 3 stimulus bill that has not yet been finalized. So we don't know exactly how that's going to turn out, but I don't know about 75K. What I do know is that since the maximum weekly benefit amount under regular benefits in Texas is $521 per week, and the top stimulus supplemental benefit that I've seen mentioned is $600 per week, that would be a grand total of $1,121. So if you multiply $1,121, times the 13 weeks that the supplemental benefits are for, that would be a substantial amount. But that combined with 13 additional weeks to make out the 26 weeks, I don't know that would get people close enough to 75K to where they would feel like it's been income replacement. It would be valuable, of course, and it will be, but I don't know about that 75K.
Yeah. Okay. Are permanent residents with green cards eligible for unemployment?
They should be. Under our law, in order to be eligible for unemployment benefits, the agency has to be able to refer you to a job. And under federal law, our agency cannot use administrative funds to refer people for jobs who are not authorized to work in the United States. So if they have authorization to work in the United States, they can meet that eligibility requirement and a green card would fill the ticket. But they will be asked that, and we always verify that fact. We do a cross-check of our list of claimants with the U.S. Department of Homeland Security, and they flag for us anybody who is not on their list of work-authorized individuals, and those individuals are asked to come in for an interview, some kind of fact-finding interview. Of course, now it'd be done over the phone, but they would be asked to explain how they're authorized to work in the United States. And if they can pass that test, then they can be eligible. If they can't pass that, they're told that they'll need to address their work authorization issue before they can draw benefits.
Okay. So it says, we filed a TWC mass layoff claim last week for our staff due to closing our restaurant. Does the Texas Workforce Commission already have record of pay earned over their base period for determining their weekly payout? We were not asked to provide wage data for our team. I believe you do.
and we do have that data. We already have that data. We use all the wages reported from employers all across Texas during the base period of each claim to figure out what their weekly benefit amount and their maximum benefit amount should be. And that information is already on file. And we send a statement of benefits to the claimant. And if the statement of benefits seems wrong to the claimant is advised that they have the right to appeal that and say that, well, I should have additional wages and a higher benefit amount because I worked at, XYZ company and they paid me, X amount of wages per month. And why isn't that on there? And so that they'll have the right to appeal that.
Okay. And I'm going to start mentioning the name, or at least the first name, and that way, if someone asks a question, they'll be in a position to kind of know that maybe that's their question, if that's okay. Anna, does that make sense? Okay. So this is from Nick. It says, can employees that voluntarily decide to stay at home because they believe they are in the high risk factors for COVID-19 or because of doctors' recommendations, but they are welcome back to work when they feel comfortable or when doctors says that they can, do they qualify for unemployment? So employers that voluntarily decide to stay at home because they believe they're high risk or because of the doctor's recommendation, but they're welcome back to work when they feel comfortable or when the doctor says they can, do they qualify for unemployment?
Valissa, would you like to address that one?
Sure, and Tommy, you can add on to that if you need to.
Okay.
So under our general unemployment claim rules, if an employee electively chooses to leave, not because they are actually sick, but from fear, that's understandable. However, our current rules suggest that that individual may actually be disqualified from benefits. But there may be an argument there to qualify them under various statutory exceptions that are in the Texas Unemployment Compensation Act. So the only way to know for sure would be to file for unemployment if that were the case, to see how the facts roll out. Tommy?
Yeah, and a way that a claimant could escape disqualification for staying home rather than come to work would be to show that, well, I was doing it because my local city issued a shelter-in-place order, and I was merely complying with that. That I feel should qualify as an exception. Now, of course, my opinion is not the official agency policy. Each claim is decided on its own individual facts, and I'm not a claim examiner, but I feel very confident that they should be able to draw benefits if they were doing it in cooperation with a local shelter-in-place order or based on a doctor's recommendation. There are mechanisms in place to allow benefits if somebody has a good reason for staying at home.
Okay. And so most of my servers work less than 32 hours a week. Will they qualify for benefits?
Yes, they should. If they've been working, let's say, 20 or 25 or even 16 hours a week, those wages are going to be on record with the agency, and as long as they are medically able to work, they should be able to draw benefits. Now, eventually, once the work search requirement is reinstated, assuming that it will be soon, let's hope, then they'll be obligated to be available and actively searching for full-time work. So that requirement is more flexible now, but they should be available if need be for a full-time job.
Okay. All right, we're at 218 of the questions there that was submitted in, and so we're trying to speed up to catch up. What is the minimum wages that are needed to earn in the base period in order to be eligible for unemployment? That's Julie.
Oh,
okay.
That is a fascinating, mathematical question for nerds like me. And I got that identical question from an employment law attorney yesterday. I went ahead and did the math. It's complicated, but you can reverse calculate what those amounts would be by taking several facts into account. You have to have wages in at least 2 calendar quarters in the base period, and the total base period wages need to be at least 37 times the weekly benefit amount, and the weekly benefit amount is 1/25 of the high quarter wage amount. and the maximum benefit amount is the lesser of 27% of the total base period wages, or 26 times the weekly benefit amount. And the minimum benefit amount possible this year is $69 per week. And with all of those facts taken into account, it turns out that they would have to have wages of at least $1,728 in one quarter and $1,725 in one quarter and $828 in the other quarter. If they have that, that would qualify them for $69 per week for 10 weeks. That's the absolute, basement floor minimum.
Okay, and Anna, we'll get that calculation and that to you guys perhaps to share, but 1725 and 828 for the other, but we'll get you guys something so that you can share that with the team as well. But that's the minimum wages they needed to earn in the base period in order to be eligible for unemployment. And so we'll move to this anonymous. I'm receiving claim determination notices on employees that I have not yet responded to their initial applications. Do I still need to respond to initial applications?
Yeah, Valissa, would you like to handle that?
Yes, so you should be responding to initial applications. I may have misunderstood the first part of the question.
Okay, so I'll read it. It says, I'm receiving claim determination notices on employees that I have not yet responded to their initial applications. Do I still need to respond to initial applications?
I would say that it would be worthwhile to respond to that. Typically, that's not how it's supposed to work. You get an original notice of application for unemployment with a deadline to respond. And then only after that passes or everyone's in agreement, does a determination get issued. So it sounds like, and I'm just guessing here, that maybe something got maybe lost or not received on time, or perhaps an decision was issued before the employer had an opportunity to respond. Ultimately, most employers are concerned about whether or not their tax accounts will be charged. So if you received a decision, it should mention what the status is on the employer's tax account. And if the employer sees that they're getting charged, then all the more reason to try to respond to that. Tommy, do you have anything to add?
Yeah, definitely file an appeal if you, didn't respond to the claim notice, but you still somehow got a copy of the claim determination. That's extremely strange, because normally, if an employer does not respond to the notice of claim, it's not counted as an interested party, and it does not get a copy of the initial determination. So it was either a mistake, or the employer responded and they just didn't realize that their response was taken as a response to the claim that made them a party of interest with appeal rights. But no matter what, check the chargeability of benefits. If you're a base period employer, you should be looking for protection from chargeback of benefits. And if you don't get it, file an appeal. According to the instructions on the determination, make sure you file a timely appeal. If you don't file a timely appeal, then you're out of luck.
Okay, so this
Commissioner and Tommy, sorry to interrupt you guys.
No.
We're at 2:55 and we have so many more questions to answer. I know we're not going to get to them all, but I wanted to pick out a couple that I know I've been hearing a lot from different restaurants.
Great.
That's okay.
Good.
Give yourself a break. So one person said that they did not know about the mass claims, ability to do a mass claims filing until after the majority of their employees have filed. So spread across all their restaurants, they have more than 500 employees. Is there a way to respond so they don't have to do each one individually?
That would be a question to send to the email address for
Sure.
the mass claims unit on the mass claims page.
Got it.
I am not familiar with whether a company can retroactively involve non-mass claim claimants in a mass claim that's that will be filed in the future. So send that question to the email address on the mass claims page, and you can start a mass claim for employees who have not filed yet. But it may be impossible to retroactively include employees who have already filed into a mass claim that will be filed in the future.
This is another question from like the 224 mark, where it says, what would happen if we decided to keep paying employees as vacation or paid sick leave? Does the company or will the company receive some kind of credit or help from the government? Do y'all know?
Well, the employees who are on paid leave status are technically not considered unemployed. So if they're on paid leave, they're still employed. It's just like they're on, vacation from their company, and you normally can't file an unemployment claim while you're on paid vacation. So those individuals should not be able to file unemployment claims and be considered unemployed and be eligible for benefits. But the relief for costs that you're talking about, to the extent that there are unemployment benefits, they may be recoverable as tax credits under the Paid Sick Leave Act that is, HR 6201, and the tax credit information is on the irs.gov webpage. Go to irs.gov and click on their link for COVID-19.
Okay, thanks, Amy. Another question, as a business owner, do they need to fill out any forms for the shared work program for their employees, or is that something they need to do first?
The shared work plan is the result of a partnership between the TWC and the employer, and that requires documentation to be filed in advance. So get on the shared work plan page and follow the instructions on there. There's an email address for shared work plan as well. They have a separate email address, and Angela Ford is the director of that unit, and she's got additional staff, and they're working hard on all the additional claims that have been filed. But yeah, it needs to be worked out in advance.
Okay. One more question. Do you know if we have employees that file for unemployment because of reduction in hours? Hold on, there's a little confusion here. Because of reduction in hours, we would not be considered keeping employees paid? Wait, that question doesn't make a lot of sense. Sorry, Laura, I can't read that question. It doesn't make sense.
And go ahead and read it to us and see if we can decipher.
Sure. It's from Laura at 234. Do you know if we have employees that file for unemployment because of a reduction in hours, we would not be considered keeping employees paid? And then she's got sort of a follow-up right underneath that to clarify.
Yeah.
You'll see that?
I see it. Do you know if we have employees that file for unemployment because of reduction in hours, we would not be considered keeping employees employed rather. There's language in the new bill saying if you don't keep employees on the payroll, you don't qualify for benefits. So new language in the new bill saying that if you don't keep employees on the payroll, you don't qualify for benefits.
If that refers to the employer not qualifying for benefits, such as the tax credits, that would be true. The tax credits are available only to employers that actually pay out the required paid sick leave and expanded FMLA benefits that are provided for in the bill. But if it refers to employees not qualifying for benefits, that would, let's see, there's language in the new bills, you don't keep in, okay. The employees technically would not qualify for the paid sick leave requirements and the FMLA requirements if they're no longer on the payroll because they have been separated from employment. If they have been separated from employment before they become eligible for the benefits, they don't become retroactively eligible for those benefits. But of course, the Department of Labor and all the people who were behind that bill are urging employers to work with the employees and try to keep them employed as much as possible. And we have heard that some employers have thought about letting employees go before the effective date of the new bill, which is April 1st, according to the Department of Labor, thinking that would be a way to avoid paying the benefits. But that's not something that would be recommended. And each business has to make its own decisions, but it's something that is meant to help the entire economy, and employers will be able to get tax credits for any benefits paid out as the result of a legislation. And the good thing about keeping employees employed as much as possible is look at all the time and training and and experience you've invested in them. And it would be shame to let all that go to, a competitor when the economy picks up again. So keep them as close to your company as you can.
Got it. Tommy, I have to thank you so much for that. You have quite a fan club over here. I'm getting messages from people who really appreciate your nerdy depth and breadth of knowledge. So thank you. And Commissioner Dimerson, Emily Knight, my CEO and president, was able to join. She'd like to say a couple words real quick.
Okay.
Yeah, I think hi guys, and to everyone who's out there, I think just seeing the numbers that have been coming in and out shows just the kind of support that our industry needs. And I had an opportunity to meet the commissioner and Tommy and many of the team members long before this crisis, and can tell you that, as I shared with him earlier in the week, that there really is no better partner to us right now. I am blown away at even the idea that they would even set up this call in the middle of a crisis for all of our member companies to dial in and to get accurate information to help them make the right decisions for their businesses and employees. And, I get a little tearful thinking about it and watching Tommy so passionately share information. But, whether it's Brian, it's Melissa, and all the other folks, the Texas Workforce Commission is right by your side. I think you probably saw the numbers and some things we've been posting today, but as of yesterday, we already see about 3 million people in our sector across the nation have been laid off. We know that restaurants are trying to hold on across Texas. I think the numbers are going to double in the next 2 weeks because with dining rooms closed, it's really hard to operate our businesses. And, doing the right thing for our employees is what matters most. And if we have good, healthy businesses, we will have good, happy employees. So just a heartfelt thank you. There's not been a time I haven't reached out in the last couple of days with an emergency ask that you all haven't jumped on in a heartbeat. And at some point, we will treat you to a great meal from one of our restaurants as a great, just a really big thank you. And to everyone, we recorded this. Anna, you're doing such a great job. And we just want to keep getting you the truth and helping you. And I'm going to finish with, as Tommy said it best, we have amazing employees in the sector. So whatever you can do to keep them close to your organization, we will come out of this. The relief is coming, and we'll want those same amazing people in our restaurants. So, do whatever you can, keep using the TRA and the Texas Workforce Commission, and we're here by your side. So Commissioner and your team, thank you so much.
Yeah, Emily, thank you so much. We really appreciate it. And again, on behalf of Governor Abbott, we appreciate the leadership that you guys have in just the businesses that are out there. We stand ready to help any way we can, and we appreciate the relationship. Those 28 local workforce boards that we have out there, touch base with them as well. And Emily, just you guys call on us at any time, and we'll just keep moving forward and going. Anna, thanks a lot for hosting us this afternoon.
And get some rest, please.
Oh, yeah.
We need you for the long haul. All right. Thanks, everyone. Thank you, Anna.
Bye.
Bye-bye.